Imagine a man named James. He's hired by his neighbor to catch some horses in a large pasture. But James wanders across a property line, accidentally rounding up and selling horses that belong to someone else. He is arrested and put on trial for horse theft. At trial, the judge gives the jury specific instructions. He tells them the crime of horse theft only requires that James took the animals without permission. It doesn't matter if he knew the horses weren't his. Based on those instructions, the jury convicts him. But there's a major flaw here. The actual state law says a person has to take the horses knowing they do not belong to him. James decides to appeal his conviction. If you've ever watched a legal drama on television, you probably have a clear picture of what happens next. You expect a dramatic retrial, a packed courtroom, an impassioned speech to a jury, and a surprise witness bursting in. The reality is entirely different. If you step into an appeals court, you will not find a jury box. There are no witnesses called to the stand. In fact, no new evidence is ever introduced. If appellate judges completely ignore the raw, factual evidence of the original crime, they cannot be there to simply recount the events of the robbery. They exist to serve an entirely different purpose in our justice system. This diagram illustrates a strict division of labor in the American justice system. Trial courts handle the facts. Juries and trial judges review physical evidence and determine the credibility of witnesses. Appeals courts, on the right, strictly answer questions about the law. Because of this firewall, an individual cannot appeal simply because they dislike a guilty verdict. To move forward, the losing party must prove that the trial process itself was flawed. That requires hitting one of two specific triggers. The first is an error of law. This happens when a judge applies the rules incorrectly. Maybe they allow the jury to see evidence that should have been strictly forbidden. Or, like in James's case, the judge gives the jury the wrong definition of the crime. But the system won't throw out a verdict for a minor procedural hiccup. To trigger a successful appeal, the error of law must be a major mistake, one severe enough that it directly affected the final outcome of the trial. The second trigger is a violation of procedural due process. The Constitution guarantees defendants the right to a speedy trial, an impartial jury, and protection against self-incrimination. If the court denies a defendant any of these basic rights, the trial is inherently unfair, and the case can be appealed. Appeals courts act as the justice system's internal diagnostic tool. They look past the alleged crime to investigate whether the system's own rules were broken. An actual appellate hearing looks like an intense academic debate. Lawyers for both sides appear before a panel of multiple judges, often called justices, to present purely legal arguments. One side argues the trial court failed, while the other side defends the original procedure. As this flowchart shows, the panel has three possible ways to resolve the case. They can uphold the trial court's original decision, they can reverse the decision entirely, or they can send the case back down to the lower court to be tried all over again. Once the panel votes, their final decision and the legal reasoning behind it are published in a written document known as the majority opinion. But judges frequently disagree. The justices on the panel who voted against the majority will often publish a separate document called a dissenting opinion, explicitly laying out why they think the majority got the law wrong. Occasionally, you will also see a concurring opinion. This is written by a justice who agreed with the final outcome of the case, but used an entirely different set of legal logic to get there. These written opinions resolve the specific dispute at hand, but they serve a much larger function. They write the official instruction manual for how the law must be interpreted and applied by everyone else going forward. When an appellate court publishes an opinion, it establishes a precedent. A precedent is a specific legal principle that all lower court judges are required to follow when they encounter similar cases in the future. In the 1989 case, Texas v. Johnson, the U.S. Supreme Court ruled burning the American flag is political speech protected by the First Amendment. This single precedent forced every lower U.S. court to strike down laws prohibiting flag burning. Strict adherence to precedent is driven by a core legal philosophy known by the Latin term stare decisis, which translates to let the decision stand. Stare decisis ensures that the law remains predictable. It guarantees that the rules governing society don't wildly fluctuate every single time a newly appointed judge takes the bench. Precedents operate on a strict hierarchy. A precedent set by a state Supreme Court binds the lower courts within that specific state, but a precedent set here at the United States Supreme Court binds the entire nation. However, there is an exception to this strict stability. Appellate courts possess the unique power to overrule their own previous precedents, although rarely. This flexibility is a deliberate feature of the system. It allows the law to adapt to shifting societal circumstances, to modern technology, and changing judicial perspectives over time. The appellate system is not a do-over for defendants hoping for a different jury. Instead, it is the vital mechanism that continually refines, corrects, and updates the entire justice system for the future.